El siguiente programa es una producción independiente. Las opiniones, comentarios y expresiones del mismo no representan necesariamente las políticas institucionales de Doral Voice ni de sus patrocinadores.
Hi, how you doing this afternoon? It's Ruben Alcoba over here at Doral Voice. Thanks to the familia Esquivel. Today I'm going to be talking to MJ, the business baller. He's a very, very important person in the United States. He does business throughout the United States. He imports, exports stuff. He helps guide young individuals as well as entrepreneurs, business owners with how to first of all, import products, sell products, get the products out there. Mr. Julian also advises companies and also directs his own companies. Today, we're going to have Mr. Julian maybe ask me a few questions as to what he sees that's important in the patent and trademark field. I'll hopefully be able to answer the questions. If not, maybe he'll help me get a better answer, a better grip of everything that's going on. But again, now you know who I'm speaking to. MJ, he's over here. Please, MJ, introduce yourself.
Thanks, Ruben. Happy to be here. Appreciate the opportunity.
So tell us right now, what venture are you in at the present time before we get into with a patent and trademark game?
So right now, one of them that we got is we got an electric vehicle range extender that can take a car and add anywhere from 80 to 100 miles out onto it by an aftermarket add-on part. So that's kind of an exciting one that we're working on today.
That sounds like a great invention. But my question is, what does it take to get something like that out to the market? I can't imagine.
For that one, it's a little bit harder because it's a big market and it's a big dollar game. So that one we actually have to raise money to be able to build the right prototypes to be able to get it. So we have smaller working prototypes right now. We don't have the bigger ones yet to be able to make them precision machined.
Wow. But my question is, so you got to get the prototype going. Are you at the same time, are you working with the trademark, or have you even come up with a trademark, or is it too soon to come up with a brand to sell your EV device?
So we have one patent that's a worldwide patent, and define worldwide, you could do that better than I could, because I believe it's by sections as opposed to there's like a blanket that you file. Could you explain that?
Well, what you're talking about worldwide patent, what happens is worldwide patents is normally, it's the way you reserve, first you apply what you call a PCT application. A PCT application is a patent cooperation treaty application. And what it does is it can extend the date where you can file overseas from 12 months to 20 months and up to 30 months. It's kind of like a misnomer because in the reality, MJ, there really is no worldwide patent. There's the ability to be able to go into other countries after you initially file a patent in the home country where you're in. For example, the Patent Cooperation Treaty, it's exactly what it is. It's a treaty amongst countries that are part of WIPO, the World International Property Organization. And what happens is that treaty says, listen, normally you would have 12 months to enter into another country from when you initially file a patent. But now that you've applied for a PCT application, we're going to give you 20 months and up to 30 months so long as you pay us for the right to do this. So all countries that are inside that treaty are allow their nationals who file their own patents to go overseas and hopefully help them find the financing required to file overseas, because not only is it just filing in other countries, you also have to hire other attorneys. It's very expensive, but that the PCT route does help that they do a preliminary examination of the application, even though you've done the examination in your home country, and that guides the other countries as to whether or not they believe your invention is patentable. But saying all that, it still doesn't stop those other countries from doing their examination. Was I able to explain myself?
So when you say examination in the other countries, what do you mean?
Well, just because you file a PCT application doesn't mean that those local patent offices don't have the right to conduct their own searches and examine your application to see if it's patentable in their own territories. They will use the international search. They will use the international examination of your application that's conducted by the officer engineer who works for WIPO, really, but that they don't really have to follow it.
So my question would be on kind of on a top side level. If I'm here in the States, I file my patent, and if I get the patent or I don't get the patent, I can still file overseas. Correct?
You could definitely file overseas, but the thing is, you have, first of all, there's a couple little problems, and I'll give you an example that a client who came to me from another attorney recently that happened to them. They filed in the United States, and then before they got a foreign filing license, they went and I believe they filed in Europe. When they did that, they violated the law. They kind of messed themselves up in Europe and in the United States because they had to wait till they had a foreign filing license before they did it. But you get a foreign filing license within a month or 2 months of when you initially filed the application. But when I get that foreign filing license, it's understood just about in all countries that I would have 12 months to go into other countries, and they will respect priority. My date of priority is my invention date when I get into the other countries, right? But let's say, hey, I don't have the financing. I still don't know how viable this invention is. I need more time to decide how much money I'm going to spend in this venture. That's when you file for the PCT. That'll give you 20 months. You will get an examination in between 20 to 3 months from when you file this PCT. You have to request for an examination application. That's another fee you got to pay them, and that'll buy you up to 30 months. But once the 20 months, if you don't pay for the initial examination, right, during the 20 months, then right, you have to go into the countries in 20. If you don't pay at the 20-month level, if you pay for the examination, then it'll allow you to go into the other countries at the 30-month level. If you don't do it, then you've lost the right to protection in those foreign territories.
Okay, so if I'm here in the States and I want to go to Japan, I want to go to Germany, I want to go to Russia or wherever, I'm sure Russia's probably not part of it, wherever I want to go, I have to file and pay in each of those countries.
That is correct.
So if I don't, that means if I go into Germany and I don't go into Italy, someone in Italy can make that same product and sell it.
No, because right there theoretically you're correct, but the only problem is you have your European community. The moment you go into Italy, the moment you go into any country in that community, you're protected in all the other territories. That's their own, it's like the United States, the European community. Let's just think about it in the same manner.
So when you said earlier your priority date, what is the fastest way that I can be able to get a priority date and protect myself?
Well, your priority date is the first date that you file either your provisional or your real patent, right? That's another issue we could talk about in a few minutes. But the priority date is when you initially file that application. That's your priority date. That's your date that you have 12 months from that moment to either file overseas or file the PCT to give you 20 to 30 months. That's the priority date.
So explain a provisional to me versus a regular patent.
Okay, a provisional is a patent application that's submitted. It's submitted usually when you're afraid that someone may present something similar to you at the same time. It could also be presented when you don't have the funds to file a full utility patent application. When you think, I got all the concepts there, but I might have further concepts to develop, but I don't want to really develop them because I'm afraid it's very competitive. Everybody's working on the same thing. So what I want to do is I want to try to get at least what I have to this moment protected, or maybe I've disclosed this invention. It's almost been a year. I'm afraid that if I don't file this provisional, someone's going to use a time bar against me, saying, "Hey, you talked about this more than 12 months ago, right? Months, not years. More than 12 months ago. So now you're barred from filing a patent." So whenever I discuss my patent in public, and the 12-month period comes, if I'm lucky enough that no one else has filed for a patent or filed another writing on it, I still may have a right to protect my invention because the United States and most countries are first to file countries. So if you're going to start discussing your invention, if you're going to start shopping your invention, if you're going to start using your invention, right, but you're not ready to file the utility patent application, then what you want to do is you want to file your provisional. with as much information as you can to be able to realize, to enable your invention, right, with the patent office, because the provisional is only as good as the information you provided when you filed the application. If you do not provide the information required to allow someone to practice, enable that invention, that provisional is worthless, because you have not given enough disclosure for something for you to be given a priority date. What does that mean? If I need 7 parts to come up with my device, but I broadly describe only 4 parts, but when I write my patent there's 7, I'm only going to get protection from that priority date for that first 4 parts, even if they don't use. But those 3 new parts, those 7 parts that I put in my real application as being essential to my patent, those will have a priority date of when I filed the second application, which would be the non-provisional patent, which would be the patent that actually gets examined. A provisional patent does not get examined. So if you're thinking you're going to have any protection, you do not. All you're doing is reserving a priority date, and what you're reserving is the information that you gave them on that date that you filed. If that information does not allow someone to use your invention, then really what you've just done is pretty much tricked yourself into believing you had some type of protection. And should someone file something that's more complete before you file your real patent, then that person would have priority for it over you, and you really would not be able to stop them unless you would be able to show that your invention was already disclosed, and at the most that you would be able to do is prevent them from getting a patent. Because you yourself now would also be barred from getting a patent, because the United States is a first to file system.
So back on that, with the provisional side, and you say so much detail, and I guess I'm not super clear on what that is. I mean, I understand what detail is, but if I have a patent, I file a provisional, I'm assuming that the provisional is cheaper and easier to file? Would that be true?
The provisional does not have claims. The claims are your metes and bounds of your property rights of your patent. So a provisional, pretty much I'm throwing everything up against the wall. I have all the colors to make a painting. I get a canvas, I throw the paint on the wall. I hope everything sticks. I hope that everything I've thrown on the wall is enough for me to be able to pull out claims in order to be able to define my patent. And hopefully, not only did I throw it against the wall and it sticks, that it somehow makes sense, and I allude to the fact that I'm going to connect these elements together. Then that provisional would end up, for the provisional, I would also have to need drawings if it's a device. For a provisional, I just need the description, the device, right, and a data sheet, which is just a simple thing, who the inventors, who the owners are. But with the real patent, I actually need to define what I am claiming is my invention. What that means is, if I got 6 elements, how those 6 elements work together. You know, I just can't say, hey, here are the 6 elements, and you figure out how they work. I have to show how those things hook together, work together, and what makes those elements, what's the advantages of putting those elements together to give me a benefit. Because if I don't give the country a benefit, then there's, what's the utility, and is that utility novel, right? What is it that makes this thing, this shiny object, better than what's out there? What is it that other product was not doing? How is it benefiting society? The United States give you patents, and all countries give patents based on what benefit you're giving their citizens, their populace.
Okay, so again, just to close out the provisional one, and correct me if I'm wrong, is let's say I want to make a shoe, right? And with the shoe, I want to go through, I've got the shoelaces, I've got holes in the shoe, I've got the canvas, it's sewed onto the thing, I have a rubber base that goes around that's so thick, and I got insoles all the way across. Would that
Sure.
be enough detail for a provisional patent?
Well, it'd be enough for a provisional if it was the first shoe in the whole world. But I also have to allude as to what makes that novel. Because if I'm just throwing there, like I said, if I just do 7 elements there and I don't know how they hook up, then what have I really preserved? I've just described a shoe. Most shoes have everything there. I have to be able to do more than just throw paint on a wall. I have to be able to say, hey, yeah, this has 7 elements. They hook up in this way, or the insole has such as curvature. The curvature relieves pain. People who have flat feet, or it allows people to stand up or work about 20% more time because their weight distribution prevents backaches or whatever. I just got to come up with some reason that I have this element that has this shape or this contour that's for a purpose, right? That's for the benefit of humanity, society, or whatever it may be. If it's not a shoe or the environment, what is the benefit? Why should the United States give you a monopoly over this idea, this invention?
Okay, so with that shoe again, someone else has a patent, and what would I change, or how could I say and make an improvement on what they have and get my own patent?
Okay, that's a great question. Since we're talking about the insole, okay, let's say that this guy comes around. Okay, I have my whole shoe, my 6 elements, and the insole is really what's getting the first person to patent, because the insole has a curvature that it's approximately 30% from the front of the insole going downwards towards the back, and the curvature has a slope or whatever, right? And he says the slope is at an angle that's between, let's say, 30 to 40 degree or whatever, right? Well, for you to go around that patent, I can't go between 30 to 40, but if I say, hey, this slope is 25 degree, I've just gone around them because they put limitations, and as long as I'm outside of those limitations, I've just gone around the patent. If the shoe has 6 elements, and those 6 elements are in the claims, because the claims is your property rights, and I knock one of the claims off I could do the same thing with 5 claims, then I've also just gone around the patent. In other words, when I look at what's already out there and I want to go around it, I look at 2 things. What are the limitations? I'm looking for the word only. I'm looking at exactly what they have, and I'm trying to see, all right, he needs all this stuff to get a patent. I just got to take something out of there. I got to stay out of one of the ranges, and if I could do that, I've just gone around their patent.
We just mentioned a word only. Are there other words other than only that are like key indicators, or say, I don't want to say easier to get around, but opportunities to be able to make a different type item?
Yeah, so the words like at least, whenever you put at least, right, then I just have to go in underneath. When it's at most, I want to go above it. If it's between, I know I could have things that are not between that. Let me see what else. Temperature ranges, I could always go around temperature ranges. When they're talking about structure, when they put down that the device has a round platform, I could simply go around that by just providing a square platform. Mm-hmm. In other words, whenever they start defining structure, then I can go around that. So really what you want to try to do when you do your claims is you do them as basic as you can without structure, and whoever the patent drafter is, he starts adding structure in what you call dependent claims. In other words, the first claim is as broad as I could do it, 5 elements. I want to describe them broadly. I want to put the range there, but then I want to change in claims that are dependent on that. Then I'm going to narrow the range, or I'm going to put you exactly what the slope is, or I'm going to give you exactly the shape. And then I might have a claim 2 where it says where the platform is round, and then a claim 3 where the platform is rectangular. Mm. So the base claim should try to describe things in a very generalized way, but the problem with that is when you do it too generalized, I've just described the shoe that you first came up with. So I'm also going to get rejected. Mm. Because the patent office is going to say, wait a minute, but you just described a shoe. So that's when they want limitations, and they want structural limitations usually.
So why would someone say if you like the heating thing you said there, say between 70 degrees and 80 degrees, why wouldn't they just say any heating range?
The reason that they would do that is because they themselves might be going around another patent. Or it might be that just if it's not in that range, it just doesn't work. It doesn't function. You know, it could be as simple as that you need that hearing range for activate another element to start working.
So when
Or to cease working.
that makes sense. So do one thing is that I know is a lot of patents that are granted don't sell for one reason or another, whether it's money, whether it's the product, whether this. But a question that I've always had is from a patent standpoint, do all the patents work?
Theoretically, all the patents are supposed to work, but the way the law is written is, I just have to be able to present a written description, claims, and a drawing that allows someone else in the art, right, to be able to reproduce what I've done, right? So theoretically, things are supposed to work. Do some patents not work? Some patents are not going to work. But then the thing is, can I present something that maybe could work with more experimentation? That could fly, as long as it's not undue experimentation.
Define that.
Undue experimentation is like I say, okay, I'm going to use these 6 elements to do this, but I really don't tell you the ranges or the quantities of compositions, or I don't tell you, you know, temperature ranges that it's supposed to be able that'll trigger a reaction. In other words, as long as I provide, this will work, but you don't have to work a whole lifetime finding the solution, undue experimentation, then I've enabled it, you know? So in other words, if I'm going to do that, then I want to find a couple of scholarly articles that suggest, hey, this does work, okay, the NIHA or whatever it says that this could be used for this. I go to another article that says this could be used for this, and then logically I'm putting together that if I put all this together, it should work, right? And I have documentation to show that, right? Mm-hmm. But one thing is what could happen and what actually happens, and maybe it does work, but just the benefit is so small that it just doesn't. The customer or the people that are going to purchase the products to resell to the customer say, wait a minute, the cost to do this just is cost productive, or the benefit is just not there. I could just sell the product that might not be as effective, but the price is just so much better that the balance says, hey, let's just sell the cheaper product, because the added cost to the product doesn't merit the value. Not sure if that explained that well, but there's reasons why some products work, some products don't work.
It's not a requirement, or they're not testing them by any means.
Well, the one who's going to test it is that, no, actually, you know what the control is? It's called a litigation lawyer who says, hey, listen, you got a patent, you sold this thing, this didn't work, right? Mm-hmm. You got the consumer protection laws, right? You got the Federal Trade Commission. They would be coming after you. That's who would come after you. The cop would be the Federal Trade Commission. The consumer protection lawyer, all he's got to do is find something that you're misleading the people. He's going to get his attorney's fees. He's going to try to get your profits. If the product does any harm to someone, then you're going to have your personal injury product liability lawyers coming after you, right? So yeah, they're eventually whoever presents that, if it produces and it harms someone, they will have to pay the piper, right? I think that's what he said.
Okay, so tell me like a method patent versus a regular patent.
A method is pretty much just the steps that you would take to get to a final product, or the steps that you would take to get a solution to some type of problem that's out there. For a method patent to be allowed, usually you got to have more. It's got to be more than an abstract idea. You cannot get a patent an abstract idea. If my method patent is how to do a calculation, I'm not going to get a patent. If my method patent is a software that does a calculation, I'm probably not going to get a patent, because I could do that with my own mental steps, right? So a method patent, part of the method patent, for if you want this to be allowed, is I want to be able to provide it's introduced a microphone, a television, a screen. I got to provide all this thing, And then I got to tell them what I'm going to do with this microphone, this screen, to make it like into a system. How is all this going to work together for what benefit, right? That's the method pattern. In other words, I'm going to have composition A, composition B, composition C, and it's going to be a method to reduce a fever, where I'm going to take composition A, I'm going to wait 15 minutes. After waiting 15 minutes, I'm going to take composition B, then I'm going to wait another 30 minutes, and I'm going to take composition C, and then whatever other steps I got to take to make these three compositions work. That would be my method of using ABC to accomplish an end.
So what's more important, making the product and trying to get it to market, or having a patent?
Well, I think it plays hand in hand, because it depends. It all depends. What's more important, the product or the patent? It's hard to say after the fact, because if you don't get the patent and it becomes a great product, now you got all your competitors making the same product, right? Mm-hmm. And maybe they have more money than you. Maybe they make a nicer product. Now you're out of the market because you didn't protect the invention, mm-hmm. right? So it goes hand in hand.
But if
right?
I'm on a limited budget, what do I do, or what can, say, some of your listeners out here say they might not have as much money, they have an idea, so they got a good idea and they want to be able to make it. What process or what should they do? And then ballpark, like, what kind of costs could they expect? I mean, granted, I know it varies, but just in general.
Well, no, that what you've just described is the perfect scenario when you file a provisional patent. That's when you say, okay, I have everything I think I need, but I don't have the resources. I don't have the firepower to take this to the market, but I have this thing that I know is going to help people. I could document it. I could see how this thing could take off, but I just don't have the resource to it. And so then you file the provisional patent application, because that's going to give you 1 year to shop it around and maybe be able to get some protection for that invention, that device that you have, right? It's also going to allow you 12 months to see, does the consumer really want this? Does the public want this? Now I could discuss this without being afraid that someone's going to steal my invention, right? So it gives me a lot of leverage as how I can market, how I can try to get an investor, how I could gauge just by talking to people. Hey, would you buy this? Hopefully, it would give me enough time to maybe build a crude prototype to be able to see if it actually works. Do a couple of YouTube videos, right? Remember, I better make sure that whatever I put in that provisional has at least the minimum elements that I need to get the real thing going. Otherwise, I'm giving my invention away too by putting it on YouTube, right? But at the same time, I'm in a catch-22. I don't have the money to get this out, right? So, do I not do anything? So you gotta. It's just a business decision that someone has to make. A provisional patent could cost you anywhere from depends from a simple device from $1,500 to something that's more complex. Could go $7,000-8,000. It all depends if you got an application. It all depends if you got a complex electronic device. If you got a medical device. With medical devices, the patent office likes to see tests, runs. With medical devices, you got to be careful, because everything you do, you're going to have that product liability lawyer. You're going to have this guy. You're going to have the Federal Trade Commission. You might even have the FDA coming after you if you endanger the lives of others.
So from a provisional standpoint, you would say if I went through, I did this provisional, would that cut my cost down on the regular patent because I did all the work, did that much more work up front?
I'd like to say that would be the logic. Sometimes it would. It all depends how detailed your disclosure was in the beginning. If you gave a full disclosure in the beginning, you just couldn't file the utility, then of course it would reduce your cost when you file the final utility patent. But if what you did was just throw a whole bunch of paint on the wall, then the patent attorney, he's going to be at point zero again, because he's going to have to make sense of what you've done, and make sense of what you've done in a way that he somehow gets you the protection that maybe you didn't even know when you threw the stuff against the wall, based on whatever you disclosed when you initially filed the provisional.
Okay, so tell me, what's a copyright and why is that important?
A copyright is very simple. A copyright is just a way you display the way you put things on a tangible medium. In other words, the order, the placement on the medium could be the table. The medium could be the screen. It could be a sound recording. It could also be a pantomime. Okay, it's just the way you display something, or you display something on the medium. It's just the order of things. It doesn't protect the concept. That's why when you protect software application, what you present is 25 pages of the first of the operating code and the last 25 pages. You're pretty much just protecting the order of elements on that medium, right?
Mm-hmm.
Or your arrangement of things there.
And that's a trademark.
No, that's a copyright.
That's a copyright.
Yeah,
Got it.
copyright, because you're an author. You're authoring a work. You're arranging the way you want things are. Copyright does not protect any concept. Concepts lead to inventions. An invention is a concept that's enabled that allows someone else to reproduce it. While a copyright just protects your spark of creativity that you have when you place your content on a medium.
So back to the copyright versus the trademark. What is the difference, and why would they be important in each of their own segments?
Well, the trademark is the way you identify the source of a product. Okay, it's made to protect the consumer more so than the producer or the distributor of the product. That's why they give you the protection, in order to protect the consumer, so they know what quality, what guarantee, what price, what customer service, right? What's related with that name of the product, and who's giving that guarantee. That would be the trademark owner, right? And what does the government give the trademark owner in exchange for allowing the consumer to get that protection? Well, he's giving that trademark owner the right not to have other people dilute his name, to pass his item off for someone else, to sell counterfeit goods with the mark. In other words, they give him the right, hey, you've developed all this goodwill, all this great customer service, this guarantees with your product, all this branding, you spend all this time doing this, so now we're going to, and you're giving a benefit to the, sorry about that, you're giving a benefit to the consumer. In exchange, we are going to, in exchange, we are going, sorry about that, I apologize to our audience. I didn't believe that was going to happen, but it does, because it's live radio. So then what happens is the government in exchange gives the owner of that intellectual property, of that mark, the right to stop others from benefiting from all the work they did creating that product, that guarantee with that mark. In other words, they're going to say, hey, no, we're not going to let Joe here come and sell a product that's similar to you for $2 when it's taking you millions of dollars to develop a product that you sell for $200. Why? Because that's going to lessen the value of your product, and on top of that, it's also going to take the credibility away from your product, and people are going to know, is this the fake one, the real one? You don't know what's out there. So what have they done? They've harmed your corporate image. They've taken away from the goodwill that you've developed with the country, and that's why the courts, award substantial fees to people who to trademark owners who are willfully infringed by pirates.
So patents from a court standpoint, patents are civil, correct? Trademarks are criminal?
No, trademarks are also
Civil?
trademarks are civil.
Okay, copyrights,
They're all civil.
they're all civil.
But copyrights and trademarks and patents could also become criminal if they're counterfeit goods.
Okay, so counterfeit.
Yeah, and you're going to have federal counterfeit laws, and you're also going to have state counterfeit laws. The state counterfeit laws will allow people, you can end up with felonies. It all depends how much product you sell, because when you're selling counterfeit product, who are you harming? The owner or the consumer?
Who?
The consumer. That's why it's criminal.
Because you're not taking money
Because
away from
because the owner could sue you civilly, But what about the harm you've caused the consumer? Right? Because you're endangering the consumer. That's why it would become criminal. That's why you could sell an infringing product that sounds similar, and the trademark owner would have a case against the person selling the product. But it's another thing when you're passing off a product as the original that maybe doesn't have the UL, that doesn't have the certifications, that doesn't have the FDA, and you're really much you're tricking the consumer into buying a product that could endanger him, or maybe the product someone's paying $100 for a product that cost $1, right? So now you're stealing from that consumer, because the trademark owner has a recourse in the civil courts. But what recourse does the consumer have? He's been ripped off.
Because you see a lot of those goods that are out there, they look as good as the real ones, and then you just see them everywhere. So is there any way to be able to tell whether it's a good one or not a good one?
Not really. Not until you take it home and it breaks, right? Or your dog eats it. Next thing you got him in the hospital, spending $1,800 because maybe that product, was not the real product, and now you got to take him there and home 3 days there because the little guy just wanted to eat the plastic, which has happened to me, right? So that's where I come up with that $1,800 experience that I had, but so I imagine that would have been maybe a product that was not the real thing. Right? Because if you're the owner, if you got the real mark, you got the goodwill, you're going to try to avoid getting sued for things like that. Because you don't want a product that's going to endanger others on the market, right?
So for a new patent holder, I know we're running out of time. We got to wrap up pretty quick. So for someone who wants to have a patent, what is their process, and what can they do, and how can you help them, and how would they contact you?
Okay, very simple. The process is simple. The first thing you do is you would want to come talk to an attorney. The reason an attorney, because he's got confidentiality. He cannot go disclosure invention. He can't, if he does that, he's going to lose his bar license, state bar license. He's also going to lose his federal license to be able to help inventors out. But once you disclose your invention to the patent owner, to the patent attorney, what he's going to do is he's going to do a patent search to see if your invention is out there. That search is going to help him write the patent, but it's also going to help you realize what's out there, what makes sure it's better, is it worthwhile to continue. If it's already out there, you can't get a patent. Only if it's not out there can you get a patent. But if it's out there, and it would be obvious if it's out there, you also can't get a patent. So it's going to give you somewhat of a direction whether or not to continue to write the real application. A search typically costs between $1,000 to $2,500, depends how complex your search is, how many countries you're searching is. After you do the search, and you decide you want to go forward, then a patent's going to cost you anywhere from $5,000 to $15,000. It all depends how complex your invention is. Your invention is going to write the invention. If it's a device, you're going to have to get drawings for it to be able to allow your patent lawyer to be able to describe what the elements are and how they connect, and also to show what the benefit of those elements are. Whether it be the shape, whether it be the placement of the devices in conjunction to each other. You need the patent owner. The lawyer's job is to put the drawings, put the device, and describe it in writing so that when a jury, a judge, an attorney suing for product liability, when he refers to it, he could put the writing and describe what each element is doing. And now what the claims do, your patent lawyer is also going to write the claims, which is going to be what your property rights are. The more limitations he puts on those limitations, the easier it's going to be for an experienced inventor, entrepreneur, or a patent attorney to be able to go around that to carve a little niche out of that patent where he could sell a similar product, but that would not infringe that patent that maybe had gotten. Now, if it's a broad patent, it becomes very hard, but usually most lawyers will try to find some type of angle to somehow get in there to be able to get a patent. The process, after you do that, you pay the government to get examined. It could take either 18 to 24 months to get the first response for the application, or you could pay to get your application expedited. You would pay about $1,000 extra to get it expedited. Why would you do that? You pay that in order to get a response in 3 months. If you don't do that, it's going to take 18 to 24 months. What the next thing in the process is, an attorney for the government would examine your application. He'll do the same search. He'll try to say, okay, your patent's allowed. No, your patent's not allowed because it already exists, or your patent's not allowed because it's obvious. The attorney's job, again, is to, if they say it's obvious, is to see what's out there and see, well, no. These things wouldn't work together, or no, it wouldn't have been obvious to put this here, and this is the benefit of this, right? Once you do all that, they eventually, hopefully you've overcome the rejection, the owner allows the patent, they issue a patent, you pay the issue fee, and you're good to go. The patent is good for 20 years from the filing date. That's a good reason also to pay to expedite, because if I pay to expedite and I get a response in 5 months, that also helps me decide if, now we're gonna go turn the whole world around, turn circle, that whether I wanna go overseas or not. I'd rather do it that way than cross my fingers and maybe it'll get allowed, maybe it won't get allowed. Now I've spent $70,000, $80,000 filing overseas. If I get my patent allowed in the United States, then I know, okay, I'm gonna get protection, I wanna go into these countries. Patent protection is 20 years from the application. I think we've run out of time, so I can't really continue to talk on this matter.
But do you have any free resources or anything like that that they can come and get from you?
They can come to my webpage, www.miamipatents.com. I have a YouTube channel. They can come to Doral Voice. They can see me discuss items like this. They could also find patents I've written on the USPTO website. The resources I have will be on my page. I believe I've also made blogs describe this. I also have written a book, but this book was more geared for crypto patents. We will be writing other books to help inventors with provisionals, non-provisionals. That'll be in the future. I speak English and Spanish. My content on the website's in both English and Spanish, and I believe on the YouTube channel we have both English and Spanish. It'll be Alcoba Law Group on YouTube.
Well, just one last question. Do you give a free consultation or do you charge?
I usually give a 15-minute free consultation. I think that if I'm competent enough to help the inventor, the client, know what their rights are, what they can do, express myself sufficiently in that amount of time, so then the inventor could see if they want to work with me or not work with me.
Okay.
Okay. MJ, thank you so much for helping me out. And actually, this time I got interviewed, but it was great. I thank you for the questions. I'm here with MJ, Ruben Alcoba at Doral Voice. Thanks to the family Esquivel for allowing me this few minutes to help educate the community on patents, provisionals, PCTs, the process, and hopefully we've answered a few more questions. Again, thank you so much, Ruben Alcoba, and I'll see you next week.